Everybody, I am Dr. S. Manjula, Assistant Professor from Manna Tirumala Naikar College, Madurai. Today, I am going to discuss about a legal position of a director in a company. Let us move to the point. We have to know about who is the director of the company. In company law, a director is a person appointed to manage, supervise, and control the affairs of the company. Directors collectively from the board of directors, which act as the company's governing body. Under Section 234 of the Companies Act 2013, director means a director appointed to the board of a company. In other words, a director is an individual legally responsible for directing, managing, or overseeing the company's business and affairs. Directors are appointed according to the company's articles of association and relevant provisions of company law. Directors must act in good faith in the best interest of the company and its employees, shareholders, and the community. He must exercise due care, skill, and diligence. He must avoid conflicts of interest and misuse of position. There is a different types of directors. One of the directors called executive director. He involved in day-to-day management, and non-executive director. He provides oversight and advice. Independent director may act as ensures fairness and transparency in the companies. Managing director or whole-time director. He has substantial powers of the management. And the next one is nominee director. He must be appointed by the institutions or investors to represent their interest. Let us legal position of the director. Directors are sometimes described as agents of the company, trustees of the company assets, and he must act as a officers under a company law. Moreover, a director is like the brain of the company, making key business and policy decisions, ensuring compliance with laws and protecting shareholders' interest. A director is a person chosen or designated to oversee a company's business and operations. A director is not an employee or servant of the company. They are the professionals hired by the company to guide the activities of the company. The group of directors within a company is collectively called as board of directors, which hold the highest executive authority in managing and running the company. The legal position of the directors are directors as a trustee, directors as agent of the company, directors as a managing partner of the company, directors act as a officer of the company, directors as an employee of the company. Legal position of directors may be, he may be acting as an agent, trustee, and managing partners. Directors are individuals who have been duly appointed by the company to direct and manage its affairs. Agents and trustees do not cover all of their powers and responsibilities comprehensively. Legal position of director in a company, which is that they are essentially business people managing a trading entity for their own benefit and the benefit of all the shareholders. Directors act as agents. A company cannot independently take action in its own company and requires a representative. This representative role is fulfilled by the directors establishing a principal-agent relationship. Directors possess the activity to act and make decisions on the company's behalf. Any contract or transaction made on behalf of the company render the company responsible while the directors remain free from personal liability. Directors merely sign and execute contracts on behalf of the company. When directors enter into contracts in their own names rather than on behalf of the company. When directors sign contracts or agreements in a manner that is unclear whether the company or the director is signing and who will be liable for future obligations. Director as a trustee. The legal position of director is also a trustee. This trustee role implies that directors manage a company assets and work in the best interest of the company. A trustee is someone who can be entrusted with the company's resources and act to achieve the company's objectives rather than for personal gain. A trustee is granted certain powers such as share allocation, issuing calls, accepting or declining transfer. Directors act as a managing partner. Directors of a company act as representatives of the shareholders carrying out their will and objectives. They work on behalf of the shareholders and their interests, which grant them significant powers and the ability to perform functions that are essentially proprietary in nature. The company's Memorandum of Association and Articles of Association establish the Board of Directors as the higher authority for policy and decision making. Director act as a employee or officer. Shareholders elect directors in a general meeting convened by the company. Once a director is elected, they have rights and powers granted to them by the law. These powers and rights cannot be revoked by the shareholders, and shareholders cannot interfere in the decision making process of the directors. Director possesses these substantial powers and rights. They cannot be classified as employees of the company. Employees typically have limited authority and work under the direction of the employer without the ability to interfere in decision making. Hence, the legal position of director can be considered as an employee. Thank you for watching. Thank you.